It is May 11th of 2026, and this is the Court Gallery. Today we see a full spectrum of court chaos. We have a man with 11 prior violations trying to use a family tragedy as an excuse, and Mcnally is having none of it. Then Judge Mcnally absolutely refuses to give a defendant special treatment, even when the officer who wrote the ticket is asking for it. And we finally get a finale to the crazy Contractor case, and Judge Dad might get big mad before it's over. We'll see a man sentenced for a drunken rampage with Judge Elmore, and we end with one of the most combative cuckoos you'll ever see, who accuses the court of being a money pit before trying to invoke her Fifth Amendment right after insulting the court. These are illegal levels of idiocy, ladies and gentlemen, and it all starts right now.
All right, people against Derek Allen Mcnally, 214-642-916. Your name?
Derek Allen Mcnally.
All right, so you have 11 prior technical violation, and there's a charge that you failed to attend the court work program on April 25 of 26. You can plead guilty, or if you are found guilty, your 771 status here could be revoked, the conviction entered, and you'd be subject to a 90-day jail term. Do you understand that?
Yes, sir.
Did you sign, read, and understand the advice of rights?
Yes, sir.
If you plead guilty, you will be giving up all those rights, and we are not going to have a trial of any kind. Do you understand that?
Yes, sir.
You have the right to a lawyer. I'll be happy to provide you with one at public expense. Would you like an attorney?
Yes.
Okay, so I'm going to go ahead and enter a not guilty plea. We'll send you out in the hallway. You'll speak to a lawyer. And then either way, you're coming back in front of me with your lawyer before you leave here, okay? Any questions?
No.
Okay, you can go out in the hallway. He'll set you up. Thank you.
Thank you.
Yeah.
I don't know whose ours is. Who's our probation lawyer today? Derek Allen Mcnally, 214-642-916.
Good morning, again, Judge and staff. John Bassiano on behalf of Derek Mcnally.
I'm gonna need Jessica in here. Your name, sir?
Derek Allen Mcnally.
All right, so he has entered a not guilty plea on this. He's got, I hope you saw this, he's got 11 prior technical violations.
The judge.
And now here he's got one count of failure to attend the court work program. How's he going to proceed on this?
Pleading guilty.
Is that what you want to do, sir? If you plead guilty here, this would be your 12th. And you could have your probation revoked and be incarcerated for 90 days. Do you understand that?
Yes, sir.
And did you sign, read, and understand the advice of rights?
Yes.
You plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes, sir.
So the charge you failed to attend the court work program on April 25th of 26, how do you plead? Did you fail to attend?
Yes.
Why weren't you there?
My wife was assaulted by her eldest sister.
By what?
Be there for the kids.
Wait, I didn't hear you.
My wife was assaulted. My wife was assaulted by her eldest sister with a drug problem, and I needed to be there.
When did that occur? I would just want you to tell me when it occurred.
About a week ago.
About a week ago?
Wife's been like, I already contacted Gibraltar.
Well, what does that have to do with it? You're.
I didn't take care of my daughter, but
This is May the 11th, right?
yeah,
If it happened back on May the 4th, you said about a week ago,
contacted Jessica.
what does that have to do with you not being here for the court work program on April the 25th?
I had to take care of my daughter and the animals.
Wait a minute. You're acting like this assault on your wife caused you to not be here on April.
No.
Wait. I don't want to be interrupted. You told me your wife was assaulted by her sister. Is that not what you said? Were you not trying to lead me to believe that she was assaulted on or around the time you were supposed to be to the court work program and therefore you didn't appear?
I should have prioritized. I contacted you, Walter, to go tomorrow or set on free this entire week. I'm gearing up for
Listen,
MDOT certification.
listen.
Chuck, it just sounds like, if I may interject, it sounds like this gentleman's been overwhelmed with a lot of things that have been going on in life and it's happened.
He tried to make it sound like he didn't show up on the court work program because his wife was assaulted by her drug addict sister. That's what he made it sound like. And then it comes out that that was a week ago, and yet he was supposed to be on the court work program 16 days ago. Right?
No, I failed to prioritize.
Judge, if I could.
Yeah.
So Derek was actually scheduled for, he only had the 1 day left in the court work program. His case was set to expire May 1st. So I told him he only had a few opportunities. We were originally scheduled for April 11th. He emailed me stating there were some issues in the family situation. He wanted to reschedule. Fine. I told him he could reschedule. He then rescheduled for April 18th. He then contacted me saying there was issues with his wife. There was something going on with his wife. He couldn't do it. He needed to stay with his daughter. I said, fine, you have one final opportunity on May 25th. He stated
April
again,
25th, you mean?
April 25th, I'm sorry, yes, Your Honor. On April 25th, he then emailed me again and stated that he couldn't do it, that his wife was going through severe mental health problems and he had to take care of his daughter. Again, I gave him all the opportunities possible. There was no other options after that. So this is 3 dates in a row that we scheduled for court work program. There was issues each time for rescheduling. I gave him the opportunities to reschedule, but again, we've now run out of time. We don't know what else to do.
Judge, if I may interject, with regard to the wife, I believe it's his ex-fiance with whom he has an 8-year-old daughter, am I correct?
Yes.
And at that time, there were issues that existed that could have subjected his ex-fiance to CPS problems, and as a result, Mr. Mcnally intervened, and it just sounds like this gentleman, although he's been semi-responsible here, has tremendous, responsibilities, and he certainly wants to finish this off. And shame on him for not availing himself to Ms. O'Donnell's overtures over here with getting it done. But Judge, I'm just asking that if we can have a continuance on. I know you're upset about it, Judge, but the gentleman does work. He's not so lazy.
He's got 12 violations.
Judge, I understand that. I understand.
We've given Derek multiple opportunities. It's always something. There was money for a while that was an issue. We finally get this taken care of. Then it was an issue with the anger management. You just saw him not that long ago for another violation regarding anger management. We did get that done, but we just had one final day on the court work program. We've given Derek all the opportunities. I don't know what else there is to do.
Judge, he's a troubled young man whose head is spinning because he's thinking about his 8-year-old daughter from a previous relationship. He's got his wife's mental health issues to deal with, and as a result, I think it exacerbates his issues. Just asking for continuance, just to finish off this one matter over here, Judge. This is all we're asking for. I know you're fed up. I know Ms. O'Donnell's fed up, but we're almost.
How could we not be fed up? We've given him multiple.
Understood. I understand, Judge. He's just so close to completing.
This has been going on since August of 24. No, you can only have so many of these, okay? I could have done this a long time ago. Anything else you want to say?
Judge, I'm just asking that there be no jail time because he's close to his MDOT certification, given the mechanic's license.
Does he owe any money?
He does not owe.
How many days?
He has 7 days credit jail. He gave us back in October. It doesn't look like there was any credit
He
days.
also did core work program for 2 or 3. How many of those?
The day that he completed a court work program, he completed 6 days, Your Honor.
So he's done 6 plus 7 is 13, right?
Yeah.
I'm not going to assess any fines. I'm going to revoke probation. You're to serve 20 days, credit 13 for 7. You're in custody for 7 days. I'm sorry. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand that?
Yes, Your Honor.
Any questions?
Judge, my question is, when would we start this?
Right now. He's in custody right now. Sorry. Have a seat over there, sir. Good luck. People against Prince Gibson, 26B150554. Okay, your name?
Prince Gibson. Officer here beating process on the waste.
So let me just see something. Failed to yield causing an accident. Why does he want to dismiss it?
Your Honor. Sir, that issued the citation. The issuing officer requested the citation be dismissed.
What? Does he not, should he have not written the ticket? Did he make a mistake writing the ticket? He's gonna have to come in here and tell me why, okay? I mean, he wrote it. And I don't have a problem if there's a problem with their case, but I mean, he wrote it for fair to yield, and then you guys are saying here something like no injuries, both vehicles drivable, respondent paid damages. That means he paid damages, so he thought it was his fault, right? So why are we dismissing unless somebody knows somebody, and I don't do that, and they all know that, and I wish they wouldn't do that. Is Whitehead working today?
Yes.
Call him up. Tell him to get on Zoom. Have a seat. I'll see what I'm gonna do with this. Prince Emmanuel Robar Gibson, 26B150554. Officer Whitehead, can you stick your name in, your face in here, please? Your name, sir?
Prince Gibson.
Officer Whitehead, good morning. Your name?
Officer Whited, Brownstown Township Police Department. I'm just sorry for my attire, Judge Mcnally.
Yeah, can you start your video?
Yep, 1 second. I'm trying to do it from my phone. We're in the patrol car parked.
All right, your name?
Officer Whited, Brownstown Township Police Department.
You're not at work right now?
I am. I'm a passenger in the patrol car for a training
Okay.
officer who's on
All right.
shift.
But you guys are stopped, right?
Correct. Yep.
So let me ask you a question. You wrote Mr. Gibson here for failure to yield.
Yes, sir.
And this is what the officer wrote. Issuing officer requests citation be dismissed. No injuries on crash. Both vehicles drivable. Respondent also paid damages. Who was at fault in this accident?
So originally, I wrote Mr. Gibson for the failure to yield. He was at fault. The other vehicle pulled into a private business and parked, but they weren't comfortable driving it, so they had it towed privately. And I'm not a car guy, so I didn't know the damages. And they said that they would work out the damages between them, and they were to contact me if they worked that out, which they did. And I spoke to both parties, and I told them if it was worked out between them for the damages, that I would try to dismiss the ticket for them.
Can't do that. I mean, if I do that, I got to do it for everybody. You know, if somebody's going to get two people get in an accident and there's an accident, I mean, just because somebody pays damages or restitution, I just can't do that. I'm not comfortable with that. So I'll set aside the default judgment. You can take your choice. I can either send you back there and maybe you can work out impeding if there was minor damage and no injuries, or you can set it for an informal hearing, whatever your choice is.
Okay. But Your Honor,
I'm not going to dismiss this ticket. Just had a lawyer whining in here that I didn't want to dismiss her ticket. I don't play games in here, okay? I'm just telling you. You get in an accident, it's your fault. You're going to at least get impeding, period, plain simple. I don't care who knows who, what they do. I don't care. We're good. I'm just telling you, I'm not dismissing your ticket. They're not going to get, we're not getting in the habit, they're not going to get in the habit of this over here. We're not getting in the habit of this. We're not doing it. So you can either set it for an informal hearing.
but from when the officer said he only wrote the ticket, if we had to go through insurances for that purposes, there was no reason to write a ticket.
Listen,
There, Michigan that being
I want to make sure I understand. Did you or did you not say that Mr. Gibson was at fault in the accident?
Yes, Your Honor.
I'm not treating you better. Nobody else gets that deal in here. I'm not treating you better. I don't care if you're a congressman. I don't care who you are. I'm not treating you better.
But sir,
They don't pay me enough to argue with people here, okay?
no, I mean,
I don't mean to be a wise guy, but I don't go for special treatment. And if I do this for you, I gotta have those girls hire 28 more people. And then they gotta go through the last files I've done for the last 30 years and bring all those people in here so I can undo their tickets and dismiss their cases and refund their fines. I'm not doing it. I don't care how nice he wants to be. So you can decide one of two things. You can either go back in and tell them, yes, you're willing to take impeding if they'll give it to them, or I'm setting it for hearing. And I'm going to give you a date, officer, when I know you're here. We can't be doing this. If they work out civil damages, then it's okay. What do you want to do?
so I talked to the officer.
If you want to go back and talk to, officer, don't go anywhere.
So pretty much just, you just want to do impeding traffic. That's what I'm saying.
If you qualify, listen, pretty cut and dry guy.
I thought it was civil when the officer said he was gonna drop the ticket, everything was taken care of.
You're not doing underhanded garbage that comes in here in front of me.
And sir,
You hear what I said? Hang on. I'm not doing that. I don't know where people are coming up with this stuff. I'm not doing it. When they decide to issue a citation, they've never called me up and said, Judge, should I issue a citation? Not one time. I've been here 31 years and 4 months and 11 days. Not one time have they ever called me up and say, should I issue a citation? But once they do, when it comes through this little route here, I'm treating everybody the same. And they're not going to start with underhanded deals. And I don't mean underhanded in the sense that it's crooked or anything else. They're just not going to make calls here about what's going to happen with cases when I've treated the last 1,982 people times 5 differently than they're asking me to treat you. It's not happening. So you can either go talk to the officer about impeding. If you qualify, I'll be glad to do it. If you don't, and you want to have an informal hearing, be glad to set that. You got to be careful with this, officer. Please don't do that again. I mean, really, this is not, they go work this out in some, damages situation. Nobody's even entitled to restitution on civil infraction cases. They can make small claims or general civil case arguments and file those.
I understand.
go back?
Judge. I think it was just a miscommunication and a misunderstanding between myself and Mr. Gibson on the resolution for the crash, but
Whatever.
I completely.
I'm just not doing it.
I
Okay,
completely
you want to go talk to them about
I'm gonna
it?
talk to
Okay. I'll be glad to give you this file, John. Take it back to Harabedian. Don't go anywhere, officer, in case he wants to talk to you. Okay, thank you. Prince Gibson, 26B150554. Mr. Gibson, your name? Oh, is this what you want to do, is plead to impeding?
yes.
I want you to understand, this is not the least bit personal. I just can't let this go on. This is not even close.
A little advice that if this ever does have to begin, like, because technically the officer doesn't have to write a ticket for it. We just wanted to get rid of it.
That's up to him.
Yeah.
If he doesn't want to write a report, if he doesn't want to issue a ticket, I never see it.
Because he said he only did it because of the insurance purposes. If we had to go through the process.
They shouldn't be looking at it like that. But I don't, all I know is, like I was trying to tell you, if something comes through this area, if it was filed in this court, we're going to process the ticket, and I'm going to treat everybody the same. This has nothing to do with you. Absolutely nothing. I wouldn't have any suggestions for you. I'm not going to suggest that an officer start being judge and jury out there. That's it.
Pretty much, right.
You want to plead to impeding traffic?
Sure.
Well, they are not. They are not. They don't get the final say to the charge of impeding traffic, responsible or not responsible. But I want you to understand, this has nothing to do with me not liking you or anything. No. Watch any day. I treat everyone the same. 195, you're all set. Have a great day.
Quick question. I didn't take a bond for that ticket.
That will apply. So,
Page 225.
yeah, I'll set aside the default judgment, like I said. And I'm gonna, Heather, return the other $30. I'll issue you a check, okay? But go down and talk to them. Lee, Kevin Denard Lee. 25B87590, 25B87591. You're here on a show cause. Where's Mr. Lee? Your name?
Kevin Lee.
Who's this with you?
My mother.
I'm not excited about this.
Judge,
Why not?
just to let you know, he did pay one of them off today, the
Which
one ending in
one? Which
590.
one?
Ending in 590.
That's paid off? He paid 103?
Yes, that one's paid.
And how much does he owe on the other?
213.
So I'm gonna dismiss the show cause on this 25B87590. How you doing, man? Your name? What is your son doing? Is he staying out of trouble? Are you doing well in school?
Yes, yes, John.
How good is good?
I'm pretty good, amazing actually.
What's amazing?
My teachers tell me that I'm doing way much better than I did last year.
Yeah, how well are you doing this year?
I'm doing excellent.
Well, I know, but I mean, what was your grade point last year? What's your grade point
Oh,
this
I
year?
had 3 E's and
Last year? Oof. That's brutal. Now, what are you getting this year?
I'm getting about I got 2 A's, a C, and a D, and a B.
Are you studying?
Yes, John.
Is he studying?
He's studying also in sports and kind of
Then I gotta let you play sports if you don't get your grades up, right? What sport you in?
wrestling.
What school you going to?
Grieving high school.
You don't work at all, right?
Yeah,
What do you do, Bam? Do you work?
I work.
Where do you work at? For the what?
Medical team. It's called medical team
Okay.
in the nursing field.
So he owes 213 on this one, right, Heather?
That's correct, Judge.
What do you want to do? You want to pay it or you want to do community service? It's up to you.
I want to know if I can pay a little by little,
How much?
about $20.
I want you to remember, I told you you could pay $50 bi-weekly starting in November and you didn't pay anything, right? And this is May, right? We're 6 months later. I'll let you pay 20 a week or you can do community service, whatever you want. Sure. How you gonna pay that? You can go over to an animal. I get it. Well, then maybe he needs to do community service. Here's the deal. I'm gonna say you're to pay 213. Or serve 12 hours community service, and I'm paying you a lot here, by June the 20th. Can you do that? You can do community service. You can go over to Salvation Army, St. Vincent de Paul, a church, Habitat for Humanity, an animal shelter. I don't care where he does it. It just has to be a nonprofit organization. He can't go work in a dentist's office and then tell me that it was community service. You follow me? Sometimes we'll get people doing that kind of thing. No.
The church, we belong to the church and we have service, building the church. Can you do it?
Absolutely. And they're gonna send it, the community proof of, send proof of community service on their letterhead and the pastor can sign it. Okay? Do we understand one another?
Yes.
Are you guys, did you already get done wrestling?
Kinda. I'm going to tournaments.
You're doing tournaments.
Yes, sir.
What weight class?
215.
Good for you.
Yes, sir.
Is he a good kid otherwise? He's not he's not hanging out with the wrong people, right? Good. All right, good enough. Have a good day.
Thank you.
Have a great day. Thanks for coming with him, man. All right, people against Christian Cornelius Lyles Weems, 25T 647-324. All right.
Morning, Judge Deanna Petiopi, 82378 on behalf of Mr.
Your name, sir? Where you been? Why haven't you been here? Where's he been? I don't want to inconvenience anybody. Why haven't you been here?
Oh, I've just been handling a lot like probation fees and.
I didn't ask you that. I asked why you didn't show up on these tickets. Why didn't you show up?
Your Honor, it sounds like he didn't have the money to pay. He knew he should have came in and asked. He's on probation right now.
To me?
For
For what?
felony.
What kind of felons? Doesn't look like you're excited about the one you're gonna have to tell me.
No, there's a list of them in the,
How old are you, Mr. Weems?
24.
You want to spend the rest of your life in prison?
No.
he's on heightened probation.
Let's see, he's got. So, oh geez. RNC, assist, resist, and obstruct an officer. You're well on your way. Continue on this little journey by 23 or 4. Yeah, is your mother in the area?
Oh, that was there for just luck, brother, with the kid.
She'll be coming to see you in the Department of Corrections if you're not careful. You live on,
Trying, Your Honor. He has a job at Taco Bell. He started about a month ago.
you graduate?
Yeah, just like school.
Counsel, I'll give him $1,000 personal bond. He stands me waives formal reading, right?
Yes.
Don't be playing this game with me again, okay? Next time you do this, I'm gonna set a bond, you're gonna be going in the lockup there. It's no fun, okay? May 21 at 8:30 will be your court date. Personal bond, $1,000. You cannot leave the state without the consent of the court. Violate a law. You must appear in court as directed. You understand all that? You understand all that?
Yes.
Yeah, what is this? He's gonna have to come in here and tell me why we're doing this. So talking, time to playing, you know. You're all set. Good luck. Go down the hall, get your notice, and you have to fill out a petition for a court-appointed lawyer if you want one, okay? Going forward, Brandon Ursing, 26W842452. Your name?
Brandon here.
So you're gonna plead to improper parking?
Yes.
Boy, your tabs were expired for quite some time now.
I had extreme circumstances.
What happened?
Walked in a car and we were pregnant. My wife gave birth to my son 15 days after we bought the car. He was in Children's for a month and then he passed away.
Oh my God.
And so although I didn't renew them, it was extreme circumstances. So I came here to hope for leniency.
All right, you're gonna plead to improper parking they're giving you, right?
Yes.
To that charge, responsible or not responsible?
Spot.
$65. Good luck.
Thank you.
I'm sorry, I really am. Nicholas Scott Owens, 1-8T-620-7558.
Wait, judges.
What's he doing? I thought I told you, your name, sir?
Nicholas Scott Owens.
I thought I told you you had to appear in person, didn't I, at some point?
Yes, and then I got an email saying you would do it over Zoom.
And then you didn't show up June 10th
Yes, sir, I did not.
of last year. Right?
Yes, sir.
Well, what? Seriously? Now you want me to do it by Zoom a year later? I'm not doing it by Zoom. Now I thought I was a little harsh with you, I'm gonna be honest with you. But you didn't show up in June. Okay, so I don't care if you live in North Dakota or China or wherever you live. I'm not doing this by Zoom. You're gonna have to show up in person. This is ridiculous. Why would you do this?
I understand I made some mistakes.
Well, you have. And Heather, re-enter the warrant cancellation. I'm gonna indicate defendant appeared on Zoom, failed to appear in 2025, and that was on, failed to appear on June 10, 25, needs to appear in person. You mean even after I did that for you, you decided you weren't going to show up? I'm just shocked.
Yeah, I was nervous to come back. I'm sorry.
Well, you didn't need to be. But I was even letting you appear by Zoom on June 10th. We emailed you other times. Yeah, I'm sorry, Mr. Owens. You're going to have to appear in person at this point. Good luck to you. Thank you.
Sorry, Your Honor.
That's all right. Reissue the warrant, Heather. Harper. Aaron James Harper, 25B14851L. 26W841103, 25W841736, 24B146691B, 25W839353, 25W83256, 25W838175, and 25F244556. Your name? All right, I took your plea on the April 14th case. You had a lawyer at all of this, didn't you?
Yep.
Who's your lawyer?
I forgot the guy's name, but it was the guy in the room to the left.
Oh. It was Mr. Haynes last time, it looks like.
Is he here today?
He's not.
No, we have Mr. Graziani now.
John, you say have to go. Yeah.
Never seen him all the way.
So you can have a seat out there and bring all the files to him, okay? We had a change of the lawyers after a few months here. Aaron James Harper.
Good morning again, Judge. John Graziani, appearing on behalf of Aaron Harper.
This is 25B148510, and I've got a whole slew of other cases too.
Please identify.
26W844, I'm sorry, 841103, 26W8411736, 24B146691B, 25W839353, 25W838256, 25W838175, and 25F244556. I don't like these, Mr. Harper. You like to ignore courts? Is that what you want to do?
Judge, in his,
Your name, Mr. Harper?
Aaron Harper.
You shook your head. No, that isn't what you want to do is ignore courts? Because these are all old. These are all 6 of these files. And then this one here, I don't know who you think you are either.
Judge, in his defense,
I can't wait to hear it.
he does have some money available. He did complete most of the court work for him. There's one more day left, but unfortunately, he has these tickets that he has to go with.
Call in Jessica. I don't like this. Tell me what you want to say. I mean, I took his pleas to failure to attend the court work program, failure to pay fines and costs. I told him to bring a bunch of money. We've got all kinds of cases here. I mean, he owes all kinds of money. Oh, well over $1,000. Did he?
Correct.
What, does he have $1,000?
Judge, he doesn't have some money. 200 to pay today. He lost his job and he just recently.
I told him to pay $400 bi-weekly beginning. That's what he told me he could pay on October 28th. I told him that on October 8th. He never showed up. He never did anything. And you haven't paid on any of these others, and you just keep missing court dates like you're running the Pentagon or something. I'm serious.
Yeah, so since the last time I came, the two issues that I had was that.
Name? Go ahead.
I missed the court work program and I was behind on my payments.
Well, that's no shock. You were on the other 6 or 7 cases you had in here too.
Yeah, I have all like a payment plan weekend with the other stuff too. So since last.
Wait. Slow down.
Yeah.
What do you mean? We gave you a payment plan on this,
Yes.
and you just ignored the payment plan.
Yeah, and then I came to the hearing to basically let you know that I basically lost my last job. But since the last time, like the last time I was here, like a couple weeks ago.
That was April 14th.
Yep.
That was almost a month ago.
Yeah, I got a job.
Where?
It's a movie company.
How much you make an hour?
15.
Did you graduate?
Yeah, I went to college and everything.
You graduated college?
Yeah, community college, Judge.
That's okay. Where?
Kalamazoo. It's called Kansas. But
Would you get an associate's degree?
yeah, so
Why are you working for $15 an hour?
I mean, we get.
I mean, don't get me wrong, it's better than $0 an hour, but you should be getting a better job than that unless your criminal history's following you around and gonna hurt you for years to come.
Yeah, no kind of history, man. But since the last time, I got a new job at the moving company and stuff. So, and then I went to most of my court work programs because that was another reason I had to.
Why'd you miss on that date that I took your plea on? Why'd you miss on March 4th?
I believe I was late, and ended up getting.
Why were you late?
I honestly was there, but I'm thinking it started at a whole different time than what it was. And I was literally there. I just got sent home, but I have one more.
Are you going to, are you gonna grow up? How old are you?
24.
We're thinking it was a different time.
Sir, you gotta take your hat off. Sir, take your hat off.
What do you mean you think? What time did you think you had to be here for the court work program?
8:45, but it was.
Hang on. Did you tell him when he had to be?
Yes.
What time did you tell him he had to be here?
At 8:30. He's completed a day before that he obviously was on time prior to that.
You gotta grow up. You gotta grow up. Anything?
Judge, he's made an honest effort. He, like I said, he lost.
You're smiling there is why I'm smiling. You, Mr.
No,
Graziano.
I'm just saying this man's made mistakes, but he's catching up to things. He does work, unlike a lot of folks that you encounter, and I think he'll be successful. I told him if it's necessary to give blood, make ends meet. He is living with his parents, and he can do this, Judge.
This was defrauding an innkeeper. Paid nothing on this. How much did you owe on this? The original amount?
I believe it's the original. I don't think he made anything.
Judge, it is $1,467.79.
I ordered you to pay that back in October, right? And I said I'd let you pay. You told me you could pay $400 bi-weekly beginning October 20th.
Yeah.
You told me that. I wouldn't set that kind of payment plan unless somebody told me that. What were you doing then? What were you doing then?
The time that I actually lost my job.
What were you doing at the time you were here to make you believe that you could tell me that you could pay $400 bi-weekly?
Oh, I was still working, but that's like around the time that I actually lost it.
Are you listening to my question, sir? I'm asking you what you were doing for work.
Oh, I worked at FedEx.
How'd you lose that job?
Layoff.
I mean, you're way behind here.
And I'm planning on making a payment today too. Like I
For
said,
$200.
yeah, I have a new job now, so it's like.
Heather,
Mhm.
tell me how much he owes on all these other tickets, will you? You
Okay,
just tell me the amount. This one says 197. I don't have the
Yep.
figures on them.
197, 248, 260, 233, 180, and 185. And then the probation one I just gave you. Do you want
You're
that
up to
amount again?
close to $3,000. I didn't write those down, but that's where you're at, including this $1,476, $1,467. You're to serve one additional day on the court work program on top of the one that he owes
Yes.
and pay $35 for that. Well, I'm just not appreciative of this. Defendant paid $200 today. Defendant to pay $100 per week beginning. This is on the probation case. $100 per week beginning May the 22nd. You understand, sir?
Yes.
And I want all the rest of these scheduled for show cause, Heather. You're gonna schedule all these for a show cause and failures to pay. You can put them about 5-6 weeks out. And he's gonna do everything in his power to get a second job. That's what I wrote down, by the way, is get a second job. Did you get a second job?
Well,
When I told you that April 14th? Did you get a second job?
I got the first, so I had another one, but I haven't got another one. But I don't have currently have two jobs. I have one.
Well, I wrote down get a second job on that date. I wouldn't write down get a second job unless you told me you had a first job. And if you had a first job and if it was different than the one you were doing, tell me what you were doing.
So the last time I came, the job I was doing at that time, like the April, I was doing Uber Eats. So basically the second job I got now.
Maybe you should be doing that on top of this one. It's your life, son. Go down the hall, pay your 200. She'll set the rest for show cause. You can give them the dates down there, Heather. Thank you. Matthew Glenn Malone, 25B148976, 26B150688, B, 25B149968, 25T647324.
Good morning, Judge Deanne Patillo with the D2378 on behalf of Mr. Malone. State your name for the court, sir.
That me? Yes. Matthew Malone.
So Mr. Malone has missed court dates. Well, wait a minute. He just got the possession. Let me just double check these. He's got a possession use of a controlled substance from May the 10th. So he must have been arrested yesterday. He's got from the same date. Then he also has a trespassing case that he missed on in front of Judge Hesselink. That's December 19 of 25 offense date. He missed a couple of court dates. He was supposed to be here on January 21 of this year and February 4, did not show, and a warrant was issued. And then he was also in here, or supposed to be here, I should say, on 25T647324. That's in front of me. So let's take those three. That's on a driveway suspend for which he missed on January 15 and January 29. Does he stand mute and waive formal reading on those three charges?
Yes, sir.
All right. And then I've got here another case where I sentenced him to 12 months probation and he didn't show up on January. You don't like to show up in court, huh, Mr. Malone? You must be a busy, you must be a busy guy.
Your Honor, he's had a lot.
He what?
He's had a lot going on. He's homeless. So he was sleeping behind a dumpster. He didn't come back to court. He understands that he should have come back to court and asked for some sort of a payment arrangement, at least on that probation violation case. He's got some significant health issues.
Where was he? Detective, your name?
Detective Ronald Tar, Brownstown PD.
Where was he picked up at?
He's on Telegraph riding his bicycle, Your Honor. Telegraph and near Sibley, I believe.
Nights ago, where did you stay, sir?
Behind the Family Dollar store on Sibley and Telegraph.
Do you have anybody here that you can stay with?
No, sir.
Into a program, and I Googled it. It's a community outreach program. Henry Ford Hospital sponsors it.
Sure, you gotta figure it out.
And
Sure.
if Your Honor does issue a personal bond, he plans to go there to see if he can get housing. I understand.
I mean, I'd like to help him. I feel bad when people run up against tough luck, but I can't have you just ignoring case after case after case.
I apologize about that, Your Honor, but I had nobody to help me. I was going to get in the Henry Ford Wyandotte last winter, but they were jammed because of the cold weather. I'm willing to do anything you want me to do to go to the hospital. I want to get back on my feet. I had absolutely nothing. I mean, I don't have nothing. And I want them to help me get a job, get somewhere to live, and get back on my feet because I'm lost. I need help.
All right, so I have to deal with this violation of probation first. They say you failed to refrain from having contact with Tele Valley Mobile Park. This is part of a show cause dated January 12, 26 that you didn't show up on, like I said, on January the 28th. So that for that, how is he going to proceed on this?
So, you know, he had an explanation and he understands the rights and he was giving up our pleads guilty to the probation violation.
Do you understand that, sir?
Yeah, I plead guilty.
Hang on. I want to make sure that you understand everything here. If you plead guilty, this would be punishable. I just want you to know, since you absconded, this would be a non-technical violation, and you could get 90 days on this. Do you understand that?
Yes, sir.
You are presumed innocent. They have to prove you guilty on a probation violation by a preponderance of the evidence. Do you understand that?
Yes, I got an explanation for everything.
All right. And at that hearing, you would have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you're giving up all of those rights, and there will be no trial. Do you understand that?
Yes, sir.
All right. To the charge, failure to refrain from having contact with Tele Valley Mobile Home Park. How do you plead?
Guilty.
Were you at Tele Valley Mobile Home Park?
Yes, I was there watching a friend's house, Derek Bain. He went to the house.
What day was that?
I don't remember.
But it was after I told you not to go back there when I placed you on probation, correct?
Yes,
Why did you violate the order like that?
Because he is schizophrenic. He was scared. He said, I left my house open. I had nobody to watch my house met, and I just took my chances to help a friend out. That's the only reason I was in there. I have not been back.
Anybody force you to plead guilty?
No, sir.
Plea is accepted. How old is he?
59 years old.
This is sad.
Yes. Tell me about it. Living behind a dumpster, had nobody to help you. I need to get into the hospital. I'm just lost. I'm worn out. I'm lost. I need a job. I want to go to work. I need somewhere to live. This is not me. I was not brought up like this. I was not brought up like this. I was brought up by very good parents, but my family abandoned me. I took care of my parents' caregiving for 5 years, sir. And my family abandoned me, and this is what I got. I'm pleading for help from you to get me to Henry Ford Warren Hospital. I can turn myself in there today or prove to you that I will do the right thing. I'm just asking for your help.
He also has a therapist that he's working with, who's trying to help him around.
And I will not mess up this time. I guarantee you, if I get in the hospital today, tomorrow, I will prove.
Second. Does he also stand mute on this trespassing charge in front of Judge Hesselink from December 19th of 25?
Yes, sure.
I'm entering a not guilty plea there. Here's the fact, though. You needed to come in front of me. And you don't do, wait a minute, you don't do that. And now you put yourself in an awful position. Because I can't let people not show up in court. I mean, I'm sympathetic to everything you're going through, but you don't show up.
I didn't know what to say, sir. I don't know what to say about that. I apologize. I disrespected you in the court, and I apologize. But this will not.
I'm worried about the system. That's what I'm worried about.
This will not happen again. I guarantee you. I get in the hospital and I'll prove to you, and I guarantee you I'll prove to you that I'll do the right thing.
So he then went, just so you know, and went and committed another trespass at Tele Valley.
The case before Judge Hesselink.
Yes. And then he didn't show up on this suspend and the drug charge and the bicycle on roadway charge.
Well, the bicycle on roadway and then the.
That's in default. That's been in default. Oh, no, that was yesterday. We'll sort this out. Do you want to say anything else?
Yes,
No,
sometimes I think that if he is released, he does have a plan to try to get back on his feet. I think going to jail would probably set him back.
How long has he had this plan ongoing?
So he tried to get into that community outreach program over the winter, I think.
Well, this is May. I mean, what do you mean he's got a plan? Everybody comes up with these plans when they don't have.
Because he heard that the community outreach program might have some openings. So he's gonna try that again.
Yeah, okay. Well, here's what I'm doing. You got a controlled substance charge out of Brownstown for May the 10th, and you've got the bicycle charge. So I'm setting $1,000, 10% on 688B and A. On 25T 647324, I'm setting 1,000, 10%. So I'm going to go as light as I can. I'm setting 1,000, 10% on 25B 149968, as well as on 25B 148976. So I think that should be 4 of those, and it should be $400 you're going to have to pay to secure your release. You cannot leave the state. You cannot violate a law. You must appear in court as directed. You're not to go near Tella Valley. You comply with all terms and conditions of probation. And no alcohol and no drugs. You're not to purchase, possess, or consume any one of those. This supposedly was a gabapentin, no alcohol, no marijuana, no illegal controlled substances. You cannot leave the state. You cannot violate a law. You must appear in court as directed. I'm going to give you the earliest court date I can. And you can enlighten me when you come in here as to where you think you can go. But it sounds like you're not really pursuing it with much diligence, if you ask me, if you were talking about doing it in the winter and you still haven't done it. So listen, listen to me. That's what I'm going to do. I wish you didn't force me to do this. I really do. But you gotta do the right things here. So I'm going to give you the earliest court dates. Heather, are they May 13th? I got May 13th written down on Brownstown, and that's at
Yes.
9:45 in front of Judge Hesselink. And then I've got, on my case, I'm going to ask you guys to bring them over, Detective, earlier. Sentencing date, May the 13th at 9:15 on this probation violation. And then on the other 2 cases, it looks like one's out of Trenton. So I'm going to give him May the 13th, again at 9:45, or I'll make these pretrial dates May the 13th at 9 a.m. And then on the suspend charge, that's out of Trenton, and I don't believe I have a date on here. Heather, when's Trenton here again? I don't think I do. I mean, are they here this week? In front of me?
Oh, sorry, I was muted. They're not here this week because Judge Hesson's off.
She
So
off
we
all
don't
week?
have them till the 21st. Yes, but we only have a visiting judge on Wednesday for her.
But she's not here today either. She's off
Or
all
she's
week?
here today. I'm sorry. She's off the rest of the week.
All right, so I got to make that one. Tell you what I'll do on that one, Heather. I'm gonna give him a personal bond on that one, the Trenton case, $1,000. So you can only have to post $300 to secure your release. And give me the earliest court date for Trenton. Is that on the, what, 21st?
Yes.
And we'll make that at 8:30 in the morning, sir. So you have to be here on Wednesday, whether you post or not, and you have to be here. I think at, what did I tell them? The earliest time would be
I think it was 9:15.
15, okay? So I wish you well. And I'll give you a bond on the Trent case, so if everything's resolved on these others on Wednesday, maybe I can trust you to go, okay?
I'll be there, sir.
Good luck to you. You're gonna be able to post this or not?
Now, I'm gonna see if I can get a personal, please.
I'm not gonna give you a personal. You can't miss 10 court dates and get a personal on me. I'm sorry. Even under these circumstances, I'm sorry. Good luck. Malinowski versus, Alejandro Camarena, Orozco, Israel, 260-1696. Oh boy, did I do something with my notes? Sadie, I didn't give them to you, did I? Sadie, I didn't give you my notes, did I? Your names again, your name,
Jill,
your name,
Israel Camarena.
your name. All right, I gotta make sure, I went out and looked at the property, but you're gonna have to refresh my recollection, both of you. I'm gonna ask everybody here to raise your right hands. You solemnly swear or affirm under penalties of perjury that the testimony you've given these proceedings will be the whole truth, so help you God. Ms. Malinowski? Mr. Israel?
I do.
Ma'am? Okay. Can you break this down for me again? I'm so sorry.
He was hired to do the kitchen remodel.
Right,
The price was $5 to do the job.
Right.
$500 down, $2,500 at the end. And between that time, he was given $4,100 for work. $900 was for the wood, for the trim.
wait a minute. You gave him 2,500 down.
Yeah.
And then you gave him another 900, right?
900 for supplies,
So at that point, you paid him 3,400.
right, and then there was additional funds given in between that time, but the $900 was for moldings, wood to be burnt, and the labor he had for the wood. I have no wood, I have no stain, actually the stain was,
So you gave him 4,100 total?
yes,
Maybe I'm misunderstanding. The contract was for 5,000. You gave him 2,500 down. Later, you gave him $900, which was supposed to be for wood.
moldings, stain, to burn the wood, and do the labor by putting them up.
Okay, when did you give him another 700? 25 plus 9 is 34, right?
12/21 was given $400 because the
Of what year again?
26, 25.
Okay, you gave him $400 for what?
It was for the extra work that went underneath the sink, the pipes needed to be replaced.
Did he do that work?
Yes, he did. But when my new contractor came in, he had to refix because it was leaking and the water line that went from the sink to the fridge that was put in was the wrong line and it was growing mold.
Okay, let me ask you this. How much did you pay the new contractor?
$2,800.
So how much do you have into the total job? You had 25 plus 28, which is 53, plus 9, which was 62, plus 4, which was 66, right? So you have 6,600 into it, and you have it done now as you want, right?
It's functional.
As you contracted with Mr. Israel, right? The only thing that you didn't include in the initial contract that you added on was the $900. Am I right?
The $900.
And that was for the wood, molding, stain, and to have him install the wood, right?
Correct. And that was given to him on 1/13, $900. He picks it up in the.
Of 26.
Yes,
And so, but that was not included in the original contract price, correct?
no,
So honestly, I just want to make sure I'm following this correctly. Had you had Mr. Israel do everything, you would have paid him 5,900, right? And you paid him how much?
2,500 at the start of the job.
900 more, and then 400 more.
Correct.
So you paid him 38, you paid 66 total, right?
Correct. And then there was additional receipts that added up to $315 that he did bring me the receipts for, and I paid him cash when he handed me the receipt.
So that was on top of the 3,500 or 3,800, right? So it was, you actually paid him 4115. And how much do you think you're entitled to?
I would like, I feel that he did by placing the bridge. I feel that that was worth maybe $1,000. It had to be all replaced, the lines.
Wait. Let's just start with this. You contracted with him for 5,000. You paid another contractor 2,800, right?
Just to get us functional. We were 7 weeks without no sink, no water,
All right, but
no means to cook.
am I not correct that you should be looking at it like, all right, I paid 4115 to Mr. Israel. I paid another 2,800 to this other contractor. Therefore, I paid $6,915. And now ask yourself, how much more did you add on from the initial contract price? Do you understand what I'm saying?
I'm looking at the money that I spent and gave him.
You gave him 4115,
Right.
and you paid another contractor 2,800.
To get us functional.
Do you think you're entitled therefore to $1,915?
No, I'm saying, in my opinion, I feel that the work he did do was maybe worth $1,000 on everything. He did place the fridge. You know. And fix the plumbing.
Well, am I right? You basically hired somebody else to do Mr. Israel's work.
I did, and he's.
And you were gonna pay him $5,000 to do the work, right?
Right,
So he must have done some work because you only paid the new contractor 2,800, right?
correct. That was just to get us functional, what he left us with.
I don't know what you
We're
mean
still
when
at-
you're saying functional. Is this contract, is this work been done now between Mr. Israel and the new contractor? Listen to my question before you start to answer. Did that cover everything Mr. Israel was supposed to do for the 5,000?
Yes,
Then I'm having a hard time understanding.
we still have to finish the bar, but we are functional as far as kitchen and needs to cook the stove and the lines being.
Did he agree to do the bar?
No. The bar was supposed to be, he was supposed to, on the layout that I turned into the court, it was supposed to come this way, and then a bar on the other side to sit at with a kitchen nook. That still has not been done. My new contractor is gonna be finishing up the job.
And we went out there Monday, Mr. Israel. You didn't find any of the wood in there that you claimed that you provided for, did you?
There was sparkling wood there. There was plywood that I put underneath the fridge and also underneath the sink to raise it up.
No, but I'm talking about in the garage.
Oh, no, the
You
triple,
said you put that
where that pile of wood was at, that's where the trim was stacked at as well. And it was stacked with a scratch.
Listen to my question. When you went back there, did you see any of the supplies that you bought with the $900 sitting in the garage?
Some of it.
Was there any, ma'am?
No. That wood that was in the garage was purchased by my new contractor to put my kitchen countertops and raise the sink up.
I'm having a hard time with comprehending, I should say, why you are how you are coming to the damages. You were going to pay him $5,000.
Correct,
You paid him $4115.
correct.
You paid another contractor 28.
Correct,
That's 69.15.
correct.
Assuming everything that was in your initial agreement with Mr. Israel was covered, why wouldn't you, at best case scenario, why would you only be entitled to $1,915?
No, I misunderstood the question, Your Honor. I was saying that he did do, I'm not denying that he didn't do any work. He did do work. He placed the fridge, cut the hole in the wall, and placed the fridge, and did the water lines. After he was let go, and I had to call a new contractor in to get us functional hook our sink, he discovered that the plumbing was leaking, and the line that went from the sink to the fridge was moldy. It was the wrong line initial, so he had to redo that.
Comprehend, calculate your damages and tell me how you're entitled to whatever you think you're entitled to.
It would be everything that I've given him, the 25 plus the 9 plus the 4 and the $2,800 that I had to.
Plus the 315, right?
And the 315 and the additional receipts.
But you were gonna pay him $5,000 to do all this, right?
Correct. That was the agreement. That's what.
Right, and now you paid $69.15. Follow me.
Correct. That was.
Why aren't you only entitled to $1,915?
I should not be entitled to 1950. I should be entitled to the whole thing.
To what whole thing?
The $5,000 plus the 28 I had to spend on another contractor to get us functional.
You never paid him $5,000. You paid him $4,115.
Correct.
40.
I feel I'm entitled to at least 4,100, the money that I gave.
Well, he did, but you only paid another 2,800 for the contractor to finish up the other work he was supposed to do,
It's
right?
not finished. It is still not finished.
What isn't finished, ma'am?
It's not finished.
Was the bar supposed to be finished as part of the original contract with Mr. Israel?
Yeah.
Do you have a quote to have the bar finished?
I turned it into the court.
Well, tell me what it is.
This was the layout that was discussed on August 15th, 25.
Again, you gotta make sure, man, that you get things in writing. I mean, this,
It says up in the corner, the day we met, what was discussed, and that was the floor plan that he drew out.
okay, how much do you figure that it would cost to finish up the bar?
It is gonna cost me another $1,500 to have the contractor come in and finish.
Is that what the contractors provided you with an estimate of?
Yes.
So then this would cost you $84.15 to do a $5,000 job. Why'd you walk off of this? Why didn't you do this diligently? I can tell you, I remember that. You were not diligent about doing it, and you didn't have any of the materials that you claimed that were gonna be in the garage.
So initially, the 5,000 were for the cabinets only, just the cabinets, nothing else. The cabinets and the item. That was only $5,000 that was agreed upon. No inserting the fridge, no covering up there was next to the fridge, there was like a little closet, like a spice cabinet. I closed a pantry. I took the door off of there and I closed that as well. Shown right here on the picture.
We did have to close that up, Your Honor. The fridge was originally supposed to go in that space. The fridge and stove were ordered according to his measurements. When the fridge was delivered and he came to do the job the first day, I lost my bedroom closet because he miscalculated. He said, I cannot put the fridge here because of the stairwell to the basement.
Okay, tell me what you want to say, either one of you guys.
Okay, so this was additional.
What is, you're holding up?
The fridge getting inserted and the drywall work, tearing out the hole to put it in the fridge. I had to tear out the whole wall to insert that fridge because there was a sliding door in there. So the walls were real weak. So I had to tear everything out and reinforce it. We agreed, me and her agreed upon the police report, her son's involved in it. I don't know why, but the whole agreement was between me and her. And I specified that to her in the beginning of the contract. I only deal with one person and that's it. If you want to pay me and your husband gives me the orders, I'm good with that. But both of you giving me orders and both of you paying me, that's not gonna work. So I was supposed to start on the cabinets around August. The cabinets didn't get delivered. Around December, I started doing the job. I started doing the inserting of the fridge because nothing could get done with the cabinets. Nothing was turned to her right. The cabinets were messed up, they were damaged, whatever happened. The material wasn't there for the cabinet.
She paid you, she had to pay another contractor $2,800 in addition to the $4,115 she paid.
So the $2,500 that me and her agreed upon, I told her, I will insert the fridge for you, cover that cubbyhole, and that will be for the down payment. We agreed upon that. That's not $1,000 job. Tearing out a wall, drywalling it, mudding it, framing it, passing the electrical, running the line from the bottom of the basement all the way up. That's not $1,000 job. That's a $3,000 job easily.
You're out of
The fact is that you breached the contract as far as I'm concerned. No. You breached the contract.
We did.
You did. You did. You did. And you didn't have the materials in the garage that you were telling me you'd put in the garage, and I don't believe that those materials were in the garage. Did you want to say something?
I did. This job would have been completed if her son didn't threaten him with a CPO.
And also giving me a fire alarm
And
while
made
I'm
a police
felon.
report.
I can't be
That's why
around,
he couldn't go back.
hang on. I can't be around weapons or people giving me weapons while they're intoxicated with something and giving a felon a weapon. I can't be doing that. I had to walk away. Either I'm gonna be in prison for 5 years. I'm not losing my kids over her son coming to her house. Well, he lives there too. Going to the basement high with his cousins and trying to give me a gun to shoot his cousin.
That is not true, Your Honor. He was let go.
My son doesn't work there no more because my son was racially profiled by your son. He has a text message that he sent his cousin calling my son a black kid.
All right, wait a second. Wait.
Your son has that.
Wait. You guys aren't gonna talk to each other. You wanna talk to each other, you can go out in the hallway. You're gonna address the court with your comments. Go ahead.
Israel's the one who called the police because his tools were left there. He was going back to work on the house. His tools were still there. When they got there, the police were there too. Israel met them there. He was trying to get his tools back. They said there were no tools there, right? His tools were there. Along with the police report and everything else, in them saying his tools weren't there, Trenton PD had called us 3 to 4 days later.
3 to 4 weeks.
Yeah, like 3 to 4 weeks, somewhere around then, saying that his tools were at the station. So it went from them not having his tools to them having the tools and returning them to Trenton PD.
Not all the tools either.
But not all the tools are there.
So the receipt that she
You're
had,
not a licensed contractor, are you?
what was that?
You're not licensed.
No, I'm not.
She was aware of that.
You're not supposed to be doing this. You're not supposed to be getting anything off of these. You can't do that. You can't do that. You can't do that.
Can I have one more thing?
You can add whatever you want. I mean, just,
So the receipts that she has, the copies, are receipts that I paid for, and she paid me back. She reimbursed me. The receipts that I gave her without me taking pictures of were her receipts that she paid for out of her pocket. So there was no reason for me to keep, take a picture of them, because they were not purchased by me. With my money. They were purchased by me, but not with my money.
anything else anybody wants to say before I make my ruling?
I would like to say something, Your Honor.
Go ahead.
The agreement that we had in August to do the job. The order for the kitchen countertops and everything to do the kitchen remodel was not even ordered from Lowe's until September. The stove and refrigerator did not come until December. And my memory is correct, he started in December 12th. And that was when the fridge was placed, because it wasn't even delivered until December. And the day that he was supposed to come, he did come to my house on Saturday, March 7th, and said that he couldn't do the countertops because it was raining. I said, can't you just work in the house, in the fireplace room, that's our work area? He said they had to be taken outside because they had to be put together, and because if it was raining, he didn't want them to work. But he said he would be back the next day, Sunday, the 8th, to do countertop, if weather permitted. It was beautiful all day. I gave him the benefit of the doubt and texted him around 11 a.m. Are you coming today? It is not raining. I was ghosted all day,
Okay, I've heard enough. I really have.
and that's when he was let go.
Anything else?
And then that's when I got called, I was threatened, then I called the Trenton police and had them dispatched to their location. The police told me that my tools weren't there and that there was nothing for me to get from there. I did tell her son to leave my tools on the porch, I'll pick them up. He said, no. He said, you know, if you come here, you know I have a CPL
All right.
and I will use it.
I don't want to hear any more of this. I don't believe you complied with the contract, okay? You didn't. And I made up my mind last week that you not only breached the contract, you didn't deliver those materials. I'm gonna do the best I can here. I'm awarding the plaintiff $34.15 plus $83 in filing and service, $3498. Can you pay all of that today?
No, I can't.
How much can you pay today?
I'm not working right now.
Better.
I'm temporarily
Pardon?
on. I was just diagnosed with diabetes type 2.
You're gonna have
Well, not even, they don't know if it's one or
Well,
two.
you took the money. I'm gonna expect you to pay this and you're gonna tell me when. I'll let you pay it in installments of $200 weekly. I'll tell you what, I'll make it 200 bi-weekly, and I'm gonna start this on June the 8th. If you don't, if as long as you comply with that, they can't garnish wages. She can't garnish wages. That's the best I'm gonna do. And she can subpoena you for a creditor's exam, and it could get really ugly. So if I was you, I would figure out a way I could stick to that payment plan, and I would do so. Do you understand everything I'm saying?
Yes, but I can't, I can't drive right now.
Well, you got until June 11th. You're gonna have to figure out something. You were glad to take her money and not deliver materials and not finish the job. Listen, I'm not gonna quarrel about it.
But there was threat.
Hang on.
I was threatened, I couldn't.
Hey, I made my decision. I think I made that clear. I'm not arguing with you. $200. You're gonna pay $200 in that starting weekly on that date. If they don't, you can have him subpoenaed for a creditor's exam. You can make him bring all of his real estate, bond holdings, stock holdings, bank accounts, savings and checking accounts. You can make him bring everything, his tax returns. They got a form order. You got to stick with this. You were wrong, period. You can't be doing this. You're not licensed. Should have been worse. I don't want to hear any more. Good luck.
All right, our next file here this morning is People of the State of Michigan versus Edmund Arnold, ARLT. Case number here is 26-14202-FH. Appearances from counsel, please.
Hey, Carl, on behalf of the people. I'm Jeff Harrison. I'm here on behalf of Mr. Earl. He is in pretrial for pre-sentencing custody and will be joining us forthwith, I'm sure.
All right, thank you very much. Mr. Arnold is being escorted here in the courtroom and is now at the defense table. You may all be seated. Mr. Fallon.
James report.
That's even his file. So he shows up in some field. I'm just teasing. All right, we are here today for the sentencing on this case. And let's take a look here at the pre-sentence investigation report. There he is, everybody. Mr. Sanity is now returning to the seat. All right, we're here today for sentencing on. This file includes convictions based upon pleas to 4 counts. I don't think I saw any corrections, at least I didn't note any yet. Mr. Carnes, how about you? Is there any amendments, corrections, or objections to make to the contents of the report?
Yes, Your Honor. I think OB4 should be properly scored at 10 points. I did reach out to Ms. McDaniel in anticipation of this, and she and her children have been seeking counseling through a program at the church. And that proposal will not change the guideline.
Right, and nothing yet.
I should say it won't change the guidelines on the most serious offense. I honestly don't think it will.
All right. So we are adding 10 points underneath OB4 for serious psychological injury that require professional help or treatment. That's as to well, is it all right, so that goes to count 1, and that'll increase the total OV to 70. Does that make any change?
I only looked at the most serious charge, which would be the second page. I can look real quick.
Okay. It does not. Change on count 1. Then we proceed next to the public safety offense, which is the discharge of the firearm. And that is a class D offense. And B4 should be scored there. So that's 10 points. That changes it to a total of 65 OV points. Wait a minute, look at that last one. What did I say? Yeah, never mind. It still
goes up to 70.
Yeah, the last one though, F, no, did not have any change. Now we're on the class D, and that is not going to change the guideline range there either. Then we turn to possession of a firearm. Add 10 points there. Total goes from 55 to 65. However, once again, that is, this one's actually a class E. Change the guidelines there either. Any other challenges, corrections?
One minor correction on the on CFJ 284, page 9, convictions 10 and 11 both say to be.
Well, they're not convictions, they're not these.
On instant offense. I think we should just cross out on instant offense. It's confusing.
Yeah. It wasn't, they weren't dismissed based upon this. There was another. All right, that's a good point. Yep. That would have been for this for part of the plea as to count. So. Anything else, Mr. Carnes?
No, Your Honor.
How about you, Mr. Harrison?
I have no proposed changes to the language in the report.
Mr. Carnes, any statements from victim?
Yes, Your Honor.
Thank you. Carnes, would you do me a favor and please turn that podium around since ma'am, your first name?
Mariah,
Please spell it.
Mariah,
And your last name?
McDaniel, McDaniel.
And the young woman standing to your left.
Autumn,
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 same last?
Hicks,
Hicks.
Hicks.
All right. Autumn, good morning. I like your ribbon. Yes, ma'am. Mariah?
My name is Mariah McDaniel. I'm a married, stay-at-home mom of 4 kids. Autumn, who is 8, Roman, who is 7, Lily, who is 4, and Atticus, who is now 2, who are with us today. Over the past year, my family and I have been tenants of Elmore. November 2024, we moved in and turned an empty shell of a house into a home, a safe, warm, stable place to raise our kids. My husband and I helped out whenever we were able to. We hung out with Ed and his grandson, shared dinners, kept his house clean and well taken care of. We were creating what I thought was a great landlord-tenant neighbor relationship. I found out on February 1st just how wrong I was. Around noon on February 1st of 2026, Ed asked for a ride to Kingsley, which I gave. After realizing he had left his cigarettes in my car later that day, I dropped him off to his home and left to pick up my 2 older children from my ex-husband in Traverse City. Ed made a sexual advance towards me over text around 4 p.m., which I turned down. He then continued to text me saying mean things and calling me names I would prefer not to say in front of my children. Around 6 p.m., my mother-in-law called me. She said that Ed had shown up to her house. She said that he was angry at me, calling me Satan and evil. She told my husband and I that he kept saying I needed to go and he had a backhoe to bury the body. Because of the things that he was saying, when I heard the first shot came from the direction of Ed's home, I messaged my husband and said that he was shooting off his gun and hope he doesn't kill us. A little while later, my children and I heard a crashing noise come from the direction of their bedrooms. I started to walk down the hallway to check it out, but stopped when I saw 3 holes in the walls of my 2 daughters' room. I immediately called my husband and told him what I saw. My husband told me to keep myself and our children low to the ground, and he would call his mom. She works for Calcutta 911 dispatch. About 5 minutes later, she showed up and sat with us while I called 911. While on the phone with them, we heard one more shot that was fired. After the officers arrived and statements were taken, my kids and I drove to my parents where we would feel the safest since he didn't know where they lived. I didn't sleep that night until I knew he was in custody. My trust in getting to know people is gone. My hope that we will have a stable home is fading. The emotional trauma that he has caused, the fear and anxiety that resurfaces every time there's a loud noise outside or our dog yells and barks with his cackles raised towards his home. And every time there are people or headlights in the driveway is very real and an unwelcomed feeling. We have been lied to and harassed by his family since this has happened. We have had our water shut off to try to make us leave. My ex-husband said that a couple of people he works with who know Ed's son have made comments to him about the whole situation, making Ed out to be the victim. He is not. Every decision that he made that day was his own. He admitted to shooting at the home in court, knowing that people were in it. He chose to threaten my life and then act on it. What if my daughters had been in their room when the bullets went through? He shot into our home at random and could have killed us. While there was no real financial burden from the damage that he did to his own home, the emotional and mental damage was done, not just to me, but my children, and no family should have to go through that.
Autumn, did you want to say something?
When I saw our house, I felt scared. I also was afraid to be in our house and in my bedroom. I thought that we have to move. I thought that we have to move far away from family. I want to stay in our home.
Thank you, Mariah. Autumn, thank you. Mr. Carnes, I'll go ahead and turn allocution to the people first.
Thank you, and I also thank Mariah and Autumn for speaking. I think it really drives home what a horrific experience this was. First, I'd like to say I reviewed the text messages between the defendant and Ms. McDaniel, and was shocked by how polite she was throughout the entire exchange and how vile his messages were through this. The most threatening thing she said was, "My husband will come speak to you when he gets back," not as a threat, just to kind of explain how this is inappropriate. And shortly thereafter, they have these gunshots entering their home. When reviewing the PSI, I was slightly shocked at the defendant's statement. When he gave the plea, it seemed pretty straightforward, but then we have this statement that he fired in the air and accidentally shot my rental house. Ms. McDaniel said that she saw 3 shots in the bedroom. Preparing for this, I just reviewed the police report. It looks like 3 shots were fired and 2 entered the house. I don't know, one of them split. It was a muzzle loader. I admit to ballistic ignorance. But clearly there were shots intentionally fired at the home. I honestly think the guidelines are inadequate, but this was a plea. I do think 85 months is an appropriate sentence, and I'd ask the court to impose that. Thank you.
Oh, thank you. Mr. Harrison?
Well, Your Honor, it's one thing to look at the events as they unfold, particularly from the perspective of the victims here. And Mr. Carnes used the correct word. I think it's shocking. The contrast between that and the gentleman that sits to my left right now is almost incomprehensible. I'm talking about throughout his history, he's been forthright almost to a fault with regard to when he makes a mistake, he owns it. I don't recall that statement that he made about shooting in the air or whatever, but I do know this. If you look at his criminal history, it all relates back to initially marijuana, then thereafter, it's pretty clear that there's an issue with alcohol that he has yet to resolve. Does that mere fact alone stand as any sort of excuse to say, well, I'm not responsible for my behavior because I was drunk, Your Honor? No, of course not. But if the court will recall, that's not what Mr. Arlt said to the court. I have trouble saying his last name, so I'll stumble through it. If the court recalls, he was clear, concise, and forthright when he entered his plea. He even provided additional information with regard to a couple of facts in the case in response to the court's questioning. That's impressive to me. It's impressive to me that a guy in his situation, who all too often defendants come forward and say, "Oh, it wasn't my fault because I was drunk," or there was a lot of stuff going on and I panicked and I did this, and it's everybody else's fault because society put too much pressure on me. That's not the case here. He stood in front of you as a man and said, "I shot at the house. I knew people were in it." And as you can tell from his demeanor today, he's not boastful about that conduct. In fact, it was hard for him to sit through Mariah and Amber's statements because even though he and I have talked about it, and he's well aware of the harmful nature of his actions and the potential psychologically damaging aspect of it, to hear that from that little girl's mouth and from that woman's mouth here today really put a point on it for all of us in the room. All I want the court to know is that that point was not lost on Ed Mcnally. I don't know what else to say. I looked at the recommendation, and the recommendation was, I believe, for a 5-year sentence on the most serious offense, a 60-month sentence. If you'll note, Your Honor, despite his criminal history consisting of 18 entries, this is the only felony on there. Again, my reasoning behind that is not to say, well, every dog gets one free bite, right? That's not how the system works. That's not how it should work. I think due to his regretful demeanor, due to the fact that he hasn't tried to obfuscate, he hasn't tried to explain away, almost, like I said, almost to a fault, because he didn't give me a whole lot to work with in terms of what do we do with the guy. But I think that has something to say about the kind of man he is, the kind of character that he possesses, in spite of his actions on that fateful day. I've been extremely impressed with his demeanor. His state of mind has been that of not only thoughtfulness, but realism the whole time I've been dealing with him. And frankly, it shows a rare level of maturity that we don't normally see in defendants before this court. Can we explain to you what happened that day? That's always something I try to at least come up with some sort of explanation to the court. Why did this happen? What was going on? I don't have an explanation for this. Mr. Arlt doesn't have an explanation for this. In his effort to kind of piece together the events of the day, we've kind of come up with the idea that the muzzleloader was already loaded. In his drunken state, he attempted to reload it, and that's why 2 projectiles were cast out of the weapon. But the reason we didn't present that, the reason we didn't try to tell anything about that day, is that that's pure speculation on his part. As he has been thoughtful, and he has been regretful, and he has sought, perhaps for his own reasons, but more so perhaps to explain to Mariah and Amber, give them some sort of understanding of what he was going on that day, because he does not possess any ill will whatsoever toward either one of them. Obviously, toward a child, that wouldn't make any sense. But even as to Mariah, despite the language in his text messages and despite his actions subsequent to that, he does not wish her harm, and he's truly sorry that he caused her this level of anguish. Now, when we discussed the entry of a plea, and I were honest with each other, and I, basically ran the guidelines and said, look, if you do this, the likely result is going to be a prison sentence out of this case. And he not only said he was aware of that, but that he probably deserves it. In light of all of that, Your Honor, all of that information, I think the recommendation for 5-year sentences, frankly, a little strong. However, it is in the middle of the guidelines. I think the guidelines accurately reflect, particularly with the scoring change that we had today. I think they actually cover the facts and circumstances of what happened here. And I would encourage the court to fashion a sentence in accordance therewith. Thank you.
Thank you, Mr. Harrison. For all, you have the right to make a statement if you so choose. Is there anything you wish to say? I'm a piece of crap. Okay. All right. Mr. Earl, you are 50 years old. Yes. And you're old enough to know better by now. Yes, and you think it's pretty easy to admit that while the two substances that you've used, and one of them having recently become legal, isn't helping you. Life with alcohol and marijuana. What I'm seeing from you today is sounds like a different person. I have a hard time balancing and understanding the events of that day and maybe who you are when you're not drinking.
Can I say one more time?
Of course, sir.
There was 14 years where I did not drink.
Good.
And you can see it in criminal history. And then I picked it back up and it fell off the wagon and I haven't been able to get back on it.
Yeah. I understand. And that's my point. There's an Ed who is drinking and an Ed who isn't, he doesn't. And it tends to pull off that limiter that people put on themselves when they aren't drinking. Well, the facts of this case are, I think, well documented and well included in the scoring of the guidelines. I question whether or not the scoring is sufficient as well, but a few things here I look at. I think about the text messages, and those are not necessarily facts of the crime for which the crimes for which he's been convicted and pled to, but they do add color. And they add color by demonstrating that for a while, they had a fairly decent landlord-tenant relationship. And from what I'm hearing, it seemed to go both ways. And from what I'm hearing, he gets support from friends and family. But there's Ed, and there's Edmund, maybe. And the Edmund, maybe Edmund's the good one and Ed's the bad one when he drinks. But those text messages add a lot of color to tell me the switch that goes off in his head and the different personality. So while I don't punish necessarily or sentence for the text messages, they certainly do add a lot of color to the situation. Now, let's take a look here at the statement that ended the prosecutor's comment and began the defense attorney's comment. Well, it's on CFJ 284, page 5, and I definitely had it highlighted. When it asked, what did you do? Which is always a question at the PSI preparation. Quote, I had an argument with my tenant about money. That doesn't seem to be the issue. It seemed to be the text messages. Now, I'll note today, while Mr. Arlt sat here and listened to the statements from Mariah and Autumn, he couldn't look up. He had his head bowed down. See it. And I think it was sincere for whatever that's worth. Maybe today we have Edmund here and not Ed. But he's trying to sugarcoat it a little bit when he says I had an argument about money. Then it says I got drunk later in the day. All right, that part's true. And I fired my rifle in the air. That's where it came from. Mr. Harrison said that he didn't know where it came from. It came from the defendant, who told the probation officer, Mr. Saladay, I shot it in the air accidentally. Shot my rental house. That's not true. How do I know it's not true? Well, the facts of this case tell me it's not true, and the defendant pled such. These are intentional acts with intentional effects. Now, when Mr. Harrison talked a little bit about, he used the word speculative or speculation, as maybe they're trying to figure out, maybe there's a defense, maybe he was cleaning the muzzle loader. I don't know. Was it a muzzle loader? Was it a rifle? That's a different story than what we see here. There's nothing at all to fabricate. There's to support that. And I find that concerning. The defendant pled guilty. And then they come in the court and talk about, well, speculation. We could have argued this and didn't argue it. Could be embedding the case with an appellate issue, because then it makes it sound like the defense attorney saying, yeah, I had a defense, but I didn't raise it. Which means somewhere down the road, someone's going to now argue ineffective assistance of counsel and say, look, the defense attorney just admitted to it. Well, the answer is I don't think so, and I don't find it to be ineffective because none of the evidence would support it. Even the testimony and statements from the defendant contradict it. Therefore, I don't accept it. And when I read this and I try to put it all together, I'm wondering to myself, I'm surprised the defense is even asking to withdraw the plea and say it was a bad choice, ineffective assistance. Oh my God, that's not what happened. Well, even if it were raised, the court would deny it, and the court sua sponte does not accept it. Have a defense, you should present it. Do not come into the court at sentencing and tell me, well, we had one, but it was speculative. So instead, the defendant came in to save his tail and pled guilty to intentional acts. That makes no sense. So I look at the defendant's prior criminal history. It began in 1997. Made it about 2 months after getting off of probation. No, wait, 2 months into probation, sorry. And then he violated again. So the first one was for delivery of marijuana. And then 2 months into probation, he gets a domestic violence. And violence, I list these, and I'm going to call it violence number 1. Then he's got a 10-year gap rule, so goes through the score. But in 2020, boom, violence number 2, he's got a domestic violence. I'm willing to bet if I look back that that probably somehow involved alcohol. In 2000, again, on the same date, he picked up another marijuana with intent to deliver. Those cases resolved in May and June of 2001. He made it only until November, until he violated probation and operated while intoxicated. Then he makes it 7 months after that case is sentenced, and he picks up another file. That file gets dismissed, and then he makes it until 2004, and he's got a malicious destruction of property, and it's pled down to assault. Then violence number 3. Then he makes it 7 days after that conviction, and he's on bond before he's even sentenced for it. Then he picks up another assault. There's violence number 4. In 2006, he picked up violence conviction number 5. He had been off of probation for less than a year. Then I keep going. He does have a couple cases that were dismissed. Is all part of one joint deal. So he makes it to 2007, and he gets a delivery of marijuana charge. Then we turn to 2021. Now we're back to operating while intoxicated, more alcohol, and he violates probation. By the way, Mr. Saladay, it says here for number 16 of 18, as everyone was talking, I think that's incorrect. I think the status of the time, the notice of date, April 3rd, 2023. Well, he was discharged from probation back in November of 2022, and he wasn't on probation for anything else. So strike that. Then we look at these things, and driving license suspensions aren't, or some people say are not a big deal, but they show deceptiveness. In 2024, was destruction to a building in another county. And now here we are on, I think we're on violence file number 6 or 7. And the events here were horrible. Unacceptable. And I think the sugarcoating and rounding of the edges today that I've heard from the defense is because he's ashamed, and I understand that. And I honestly think you are. I honestly think Edmund. I'm sorry that Ed sometimes takes over. And that's all because it appears to be alcohol. Now, the defendant has had a couple stints in rehab, including one in Kokoski Hall back in 2024, another one in Alpena Sunrise Center in 2007. So I know that he has struggled and continues to do so. But because Ed and Edmund are physically the same person, and I don't think there's any insanity defense, anything like that, because we know that intentional consumption of alcohol does not apply. So here we go. In this file, first of all, the court sentences the defendant with $368 state minimum fees, $150 state minimum fee for the misdemeanor, $130 crime victims' right fund fee. I'm not going to assess any fines, any costs, any attorney fees. Court does exercise its discretion to sentence the defendant as a third habitual felony offender for each of the 3 felonies. For the assault with a dangerous weapon as a habitual offender third, the court sentences the defendant to a prison term of 34 to 96 months with 98 days of credit. Count 2 is the misdemeanor. There, the court sentences the defendant to to 6. I'm just going to do 98 days with 98 days of credit. As to count 3, which charge at a building, there the court sentences the defendant to 84 to 240 months with 98 days of credit. And for the last count, count 4 of 4, the court sentences the defendant to 36 months to 120 months with 98 days of credit. Find that those terms and conditions of that sentence is proportionate and reasonable. Why? Because the statements include today from the facts of the case, the prior probation violations, the prior acts of violence, the continuing consumption and returning to alcohol, knowing that it is his crush, and all the other efforts in the past, such as probation, have not worked. The sentences are within the guidelines, and therefore I find again that they're reasonable and proportionate. Have I missed anything, Mr. Saladin? Mr. Fines. No, you're. All right, Mr. Arlt, Mr. Harris is going to bring you 2 copies of one document. You're going to place your initials on one. Doing so neither elects nor waives any rights. It merely acknowledges your receipt of the copy of the document. This document tells you that you have the right to appeal the conviction and sentence in your case. And typically, while that's done when filing an application for leave to appeal, claim right to appeal after a conviction in front of a trial based upon the plea. Any appeal is done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of that document and return it to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of that document. Edmund, I'm talking using your first name for a reason. you're gonna get out just 50 years of age. Right? That's the new 30, I think. I don't know. At least that's the one I tell myself. All right. You can get out and change and end your life well. Right. I hope you can. I really hope you do. Alcohol is not helping you. I think, and I know you know that. I do really wish you the best of luck because I think Ed, pretty good guy. Ed needs to go away. Where?
Thank you, Bruce.
You made the thing.
Equilibrium Management, Faye Carmouche and Michael Workman, file 26-41827-LT.
Good afternoon, Your Honor. Norman Whitty appearing on behalf of the plaintiff, Equilibrium Management.
Ms. Carmouche, were you trying to talk to me earlier in today's proceedings?
It was me who spoke, yes, if that's what you're.
Do you understand that it's not your place and time to speak unless it's your case? Still there, Ms. Carmouche?
No, however, I've been in this courtroom many times and observed, and I observed some systemic there's some concerns in this county I'm seeing. So anyway, I think we can proceed with the case so that I can get out of this county, quite frankly.
The question was, do you understand that it's not your place to speak in the courtroom unless it's your case? Do you understand that now?
I understand it now, sure.
All right. We were here originally in February. Parties were placed into a breakout room. No agreement was reached, and a request for a jury trial was made. The parties were told that we would set this matter for a settlement conference 1 week in advance of the jury trial once the written request was made. No request was made. So a status conference was set for today's purposes. Ms. Carmouche, are you asking for a jury trial or a bench trial, or is there some agreement that you've been able to reach with the other attorney?
I have able to reach attorney or the landlord.
I'm sorry, I'm not able to, Ms. Carmouche, I'm not able to hear you.
In that question. Understanding the redundancy of some written requests where that is requested in like.
Ms. Carmouche, you're breaking up
It
very
was made
badly.
verbally in court on record. I'm where I can be with the service I have to offer. You know, because again, if I could be there in person to handle this, I would be. But this is the nature of it. So are you gonna? It's what I have. So we can reschedule if the connection's not great. That's all I can do.
The question is, do you want to have a jury trial? If you do, you have to ask for it in writing, and there is a fee to be paid for it. Or do you want to have a bench?
My understanding, Your Honor, of the law is that the request is made in the courtroom and that bypasses the written request. And I will pay the jury fee. It just occurred to I wouldn't. I requested in the courtroom, and he received the immediate correspondence that was due after the request. I requested it in the courtroom. There's no need for me to follow up with a written request. It's on record.
Ms. Carmouche, there is a requirement for a written request for a jury trial. If you wish to have a jury trial, you'll need to make a written request and pay the appropriate fee. You will have 7 days from today. You will have 7 days from today to do so.
Okay.
The next request by counsel is, while we're waiting for a jury trial to be set, is for, I believe, escrow payments of the rental payment. Counsel, do you want to make your arguments on that?
Thank you, Your Honor. Yes, at this time, we think it's appropriate for the court to order escrow of rent. We're now many months past just the pretrial date, and I think part of the reason was that that jury demand wasn't properly filed and the fee wasn't properly paid, so the court kind of was in limbo. But we're incurring rent at the rate of $1,100 a month. So at this point in time, we're now at the point where there's over about $5,600 in rent plus court costs. Prorated rent through today's date would be $709.68. We think it's appropriate for that rent to be escrowed going forward, especially considering the fact that we're this far into the case and we don't even have a jury date set yet. And so we would request that the court enter an escrow order requiring the defendant to escrow rent until the time of trial.
Specifically, again, Mr. Whitty, what amount are you asking to be escrowed?
So we would request that the normal monthly rent of $1,100 a month be escrowed. My understanding is, of course, the court would prorate that rent through today's date, or it's commencing today. So prorated rent starting today for the month of May would be $709.68. So the initial escrow amount would be $709.68, and then monthly going forward $1,100 a month.
Ms. Carmouche, do you have a response to that?
It looks like they dropped you.
Hi.
All right, Ms. Carmouche is back. Ms. Carmouche, were you able to hear the request of the attorney for escrow payments of rent?
I believe so, and I'm up to speed because I did receive a notice of hearing on plaintiff's motion for escrow. I did send them a response to that. It may not have gotten them to them until today. So, but my response to that is that I actually have been putting rent into escrow. That account has, at this moment, it's on the letter that I sent, $7,500 in it to cover the balance. To my knowledge, right now is somewhere around $6,076, but there's $7,500 in it to cover whatever late fees might accrue. Or so I've been doing that already. I can follow the court's order for escrow and move it if not, or pay the court directly. However, I feel more comfortable keeping it in a private institution than paying the court, honestly.
Mr. Whitty, what do you want to do about where the escrow is kept at?
Yeah, I'd be much more comfortable if the court held the money.
Ms. Carmouche, is there any problem?
I can submit the statement. I can submit the statement. My qualms with the court holding the money is that I do not trust that those funds will be held appropriately.
What is your basis for believing that the court's not going to hold the money appropriately?
Because my data assessment for a very prolonged period on this county is that it's quite the money pit.
Specifically, what is your assessment of the court system and what is your basis for that assessment?
Do you want to go down that road? Can we talk about entrapment of people? And there's a number of things I've observed in this county that have been very concerning. So we need not have that conversation here. I'd be happy to have it on a private.
No,
but I can pay the court directly. But here's what I'm saying is that I can offer a statement.
What is your basis for believing that the court
I don't
would
think
not
I have to communicate that,
keep your
sir.
money?
I'm gonna withhold my Fifth Amendment right to communicate my belief systems on that currently, just so that I don't incriminate myself further.
You only have a Fifth Amendment right when there are criminal sanctions appropriate. None of the statements that you're making right now have anything to do
Actually,
with
as
the
an
crime.
American, I have a right to remain silent at any moment. Are you not familiar with Black's Law? Did you go to school, sir?
The The Fifth Amendment applies to criminal proceedings. It does not apply to civil
The Fifth
proceedings
Amendment
unless there's a
applies to
potential
civil
for criminal
rights.
liability.
Freedom of speech is a civil right, sir.
Freedom of speech that's under the First Amendment. The
Right, and the freedom
remaining
to hold my
silence is under the
speech
Fifth Amendment. The Fifth Amendment
And I'm
and the
gonna do
First
so now.
Amendment are entirely different things.
And okay,
So, Ms. Carmouche, do you have any other reasons why you would not wish to place the money in escrow with the court?
I feel that I will continue to just go back and forth. So I can submit that I will follow the motion, which is that I will keep the sum up until the motion in that private account just for those reasons. But it says prorated rent from the date of the order on, I think it was 4/23, 7/45/08, and then 1,100 per month. I can put that to the core moving forward for escrow, if that's how you would like to proceed. But the remaining
Counsel,
funds that are past due to the point are also in escrow, I guess is what I'm trying to say.
thank you. I appreciate that distinction. Counsel, your proposed order with your motion said $745.08 prorated. Do you wish me to change that to $709.68?
Yes, Your Honor. I mean, that number was a number that we had when we filed the motion. Today, the number is 709.68.
Your Honor, I'm also concerned about another matter. I'm not sure if I should bring it forward now or if it's going to come up later, but I do think it's relevant.
I don't know how I would know if it's relevant because you haven't said anything yet and you haven't filed anything in writing as is typically.
Okay, so I'm waiting for your okay, but I received recently a demand for possession due to health damage, health and hazard to property. The very property that I'm proclaiming is hazardous to health. So they're proclaiming a demand for possession for that, but under the explanation as for their right to do so. Now here's the thing: I've not spent. Father and I, we're currently out. I'm traveling for work. I'm not trying to spend time there. There are notes in my response to the motion as to why. Now, all that to say, the explanation given to me in this demand for possession is that supposedly me, the defendant, this is a terrible allegation. It needs to be on record that it is absolutely absurd. The defendant attempted to hire someone to kill Cole Musel, Equilibrium Management, and his family. And that is absolutely, I was questioned by state troopers. I was flabbergasted that would even come up. I'm not sure what sort of weird family dynamic this is that I've come across. But I do know that since this has transpired, multiple vehicles on the property that I live, that this in question, have been vandalized. No, one of those people used in court.
Ms. Carmouche, hang on.
Witnessed
Ms.
it.
Carmouche, please wait.
This is getting out of hand.
Ms. Carmouche.
This is getting out of hand, Your Honor. That's a very serious
Ms.
allegation.
Carmouche, stop. What you're bringing up has absolutely nothing to do with what's in front of me today. If you wish to file a motion, just like Mr. Whitty did, you must do so in writing so that both sides and the court are prepared to deal with your issue. I can't solve all your problems.
I understand that.
Today. So if you wish to bring a motion in the future, you may do so. If you wish to have a jury trial on this matter, you have 7 days within which to make that request in writing and to file the $50 motion fee. If you fail to do that, this will be set for a bench trial. In the meantime, I'm granting Mr. Whitty's and plaintiff's motion in order for escrow. That will be the sum of $709.68 prorated for May, the sum of $1,100 per month going forward until the day of trial. Mr. Whitty, do you have any additional questions or requests for the court?
Nothing further, Your Honor. Thank you.
Ms. Carmouche, is there anything else for the court today?
No, thank you. And again, I've had some frustrations with the connection mostly, and I think that's why I've come in a little heated today. So I apologize. So anyway, thank you.
I apologize. Thank you very much. I appreciate that. That's all for today.
Yep. Bye.
Yep. Bye. You know, the thing that speaks most to me, little old me. Oh, look at this. I don't have my little oh God, that's the wrong one. There you go. The thing that speaks most to me, little old me. Yep, bite. Yep, bite. Gotta have that last word. Every single time when it's the judge's courtroom, let the judge have the last word. At least. That's going to be my last word for the night. Ladies and gentlemen, thank you very much for hanging out with me tonight. We're going to be going over to see Hutch. Rhonda, if you would, give me another link over here to Hutch. We're going to go hang out with him for a little while. And then I think Hutch is going to be forwarding you guys over to Wolfbot, because Wolfbot's got some crazy stuff going on back there. I actually hear it in the background. Kind of nutty. In the meantime, ladies and gentlemen, I have a lot of people today. A whole lot. So we're going to start with our VIP supporters, EXP Range, Marty Duvall, Mary Beth, and Julie says, thank you so much for your contributions during the stream tonight. Y'all make the world such a better place. Even if you didn't contribute like that, guys, y'all show up all the time, hang out, talk, chat, and all these other people too. And all the lurkers out there whose names may not be in this list. I don't even know how the list is made, to be honest with you. It's just it's not a little scroll thing that I found that I could do. And hey, we're doing it. Ladies and gentlemen, we do this little thing every single night of the week at 8 p.m. Central Time, 9 p.m. Eastern Time. Come on by. I'll be doing it again tomorrow night, where we'll have some more crazy court cases from the day. All that stuff was from today. Can you believe it? And I have lots more. I feel like 12 more hours worth of stuff that I need to go through. It's just not even worth talking about right now. We're going to go hang out with Hutch because he's got something interesting, I hear. And I'm going to say, from the dog and the stream boss, he was somewhere around here, I assure you. Oh, I see him. He's back over there. Thank you very much for hanging out with us tonight. It's been a pleasure to bring you these court cases of the day, and I will be back here tomorrow, same wolf time, same wolf channel, with some more cases. And I will see you then. For now, I'm your lone wolf Usul, and I am out. Marty, get ready. Get ready, I'm gonna cue you. Do the thing when I tell you to do the thing. Be ready. I'm serious. Be ready. It's gonna go when I tell it to go. I figured things out. No 2 minutes. You ready? Thank you all so much. Bye. Oh wait, I messed around and I ruined the ending. And this is the Ferris Bueller thing already, and I'm gonna say there's no more. Get gone. We're going to watch Hutch. I'm pretty sure Rhonda put the link over there somewhere. I just missed it probably. Thank you guys so much. Bye. Marty. Now.